due to the new measures on the sunrise discussion. This case concerned a constitutional dispute over the appointment of Committee Basel following a loss of political support. In the state general election held on 13 December 2022, the National Alliance, consisting of the Religious Party and the Unity Party, won 14 out of 15 seats in the state executive assembly. The remaining seat was won by the Honest Party. Following this, Haji Rafa from the Religious Party was appointed as Menteri Besar from 15 of December 2022. On 23 of December 2025, 8 assemblymen from the National Alliance submitted statutory declarations withdrawing their support for Haji Rafa. This included 3 members from the Religious Party and 1 from the United Party. The following day, the Religious Party expelled the 3 assemblymen who had withdrawn their support. On 25th of December 2025, Haji Rafa attempted to seek the dissolution of the State Executive Assembly, but he was unable to meet the Sultan due to the public holiday. On the morning of 26 December 2025, the palace announced that Sultan had appointed Mr. Altis as the new Menteri Besar, based on his support from the Unity Party members, the Honest Party members, and the 3 expelled Religious Party assemblymen. Later that day, the Speaker declared that the 3 expelled Religious Party assemblymen caused casual vacancies in their seats. Haji Rafa claims that he remains the rightful Menteri Besar as he neither resigned nor dismissed, and that Mr. Alvis does not command majority support. Mr. Alvis, however, maintains that his appointment is valid and within the Sultan's constitutional discretion. The first main issues that need to be determined is whether Haji Rafa is constitutionally entitled to continue holding the office of Menteri Besar. To resolve this issue, there are 3 sub-issues that need to be addressed. First, whether his appointment was constitutionally valid. Second, whether he had lost the confidence of the majority of the State Executive Assembly. And third, whether statutory declarations have sufficient to establish loss of confidence in the former word. So we focus on the first sub-issue, whether the appointment of Haji Rafa as Menteri Besar on 15 December 2022 was constitutionally valid. Furthermore, Section 2, Subsection 2, Paragraph A of the 8th Schedule to the Federal Constitution, in the case of Datuk Seri IR Haji Muhammad Nizar bin Jamaluddin and Datuk Seri Zamri bin Abdul Qadir, is applicable to this sub-issue. So, under Section 2, Subsection 2, Paragraph A of the 8th Schedule, the ruler has the power to appoint as Menteri Besar a member of the State Executive Assembly who is likely to command the confidence of the majority. This principle was applied in the Nizar case, where following the 2008 Perak state election, Pakatan Rakyat secured a majority of seats and Nizar was appointed Menteri Besar based on the majority support. The Federal Court accepted that the existence of majority confidence at the time of the appointment satisfies the constitutional requirement. So, as far with our case, Haji Rafa was a member of the State Executive Assembly at the time of his appointment on 15 December 2022. The National Alliance comprising RP and UP controlled 14 out of 15 seats. This clearly constituted the majority, and therefore, he was likely to command the confidence of the Assembly, similar to the station in the Nizar case. To conclude, Haji Rafa's appointment as Menteri Besar on 15 of December 2022 was constitutionally valid under Section 2, Subsection 2, Paragraph A of the 8th Schedule of Federal Constitution. Moving on to the second sub-issues, whether Haji Rafa has lost the confidence of the majority of the State Executive Assembly. Furthermore, Section 2, Subsection 6 of the 8th Schedule provide that if the Menteri Besar ceases to command the confidence of the majority, he must resign unless he requests a dissolution of the Assembly. In the Nizar case, 3 assemblymen withdrew their support, causing Nizar to lose majority confidence. Although Nizar requested dissolution and refused to resign, the Sultan determined that he had lost majority support, and the Federal Court felt that once confidence is lost and the dissolution is refused, resignation becomes constitutionally mandatory. So the application, in Haji Rafa's case, on 23rd of December 2025, 8 assemblymen submitted statutory declarations withdrawing their support. This represents more than half of the total assembly membership. Similar to Nizar, Haji Rafa argued that he remained Menteri Besar because no formal vote of no confidence was held. However, the factual position clearly shows that he has no longer commands majority confidence. Therefore, Haji Rafa has lost the confidence of the majority of the State Executive Assembly. The third sub-issue is whether statutory declarations are sufficient to establish laws of competence without a formal vote of no confidence in the assembly. In the Nizar case, no formal vote of no confidence was held in the Perak State Legislative Assembly. Instead, the Sultan relied on pure representations from assembly members. The Federal Court held that a constitution does not require laws of competence to be proposed solely through a formal vote, and that other credible evidence may be relied upon. To apply with Haji Rafah case, the 8 statutory declarations submitted against Haji Rafah are sworn legal documents that clearly express withdrawal of support. These declarations provide objectives and credible evidence that Haji Rafah no longer commands the confidence of the majority, similar to the evidence relied upon in the Nizar case. To conclude, statutory declarations are legally sufficient to establish laws of confidence, even in the absence of formal vote of no confidence. For the brief conclusion, all in all, although Haji Rafah's initial appointment as Menteri Besar was constitutionally valid, he subsequently lost the confidence of the majority of the State Legislative Assembly under Section 2, Subsection 6 of the Schedule and the principles established in the case of Nizar, he is constitutionally required to resign or seek dissolution. Therefore, Haji Rafah is not constitutionally entitled to continue holding the office of Menteri Besar.
So move on.
Now we go straight to the second main issue, which is whether the Sultan's refusal or failure to consider the request for dissolution affects the constitutional positions of Haji Rafah. So there are 4 sub-issues that I want to talk on this main issue, which is the first one is whether the Sultan was constitutionally obliged to consider or grant Haji Rafah's request to dissolve the State Legislative Assembly. Second, whether the Sultan's discretion in refusing dissolution was validly exercised under the Federal Constitution. And the third one, whether the cessation of party membership of the 3 RP assemblymen resulted in the automatic vacation of their seats under the Federal Constitution. And the fourth is whether the timing of the Speaker's declaration of casual vacancies affects the composition and the majority of the Assembly. Now we go to the first sub-issue, which is whether the Sultan was constitutionally obliged to consider or grant Haji Rafah's request to dissolve the State Legislative Assembly. So, the first rule is on the 8th Schedule Section 1 Clause 2 Clause B of the Federal Constitution, which is, in this provisions, is stated that the ruler may act in his discretion in the performance of the following functions, in addition to those in the performance of which he may act in his discretion under the Federal Constitution. That is to say, in Clause B, the withholding of consent to a request for the dissolution of the Legislative Assembly. Applying to the situation of this case to the rule, the Sultan has his own discretion, i.e. choice, under Section 1, Clause 2, Clause B of the 8th Schedule of the FC to grant Haji Rafah request for dissolution or not. Where we can see, by appointing Mr. Elvis as the new Chief Minister despite not hearing the request of Haji Rafah, it is clear that the Sultan did not want to grant Haji Rafah request for dissolution of Legislative Assembly. The Sultan, however, is not obligated to grant the request of dissolution of Haji Rafah, as it already stated under Section 1, Clause 2, Clause B that he act on his discretion, i.e. his own choice, whether he wants to withhold consent or dissolve the Legislative Assembly. So, in conclusion, the Sultan is not constitutionally obliged to consider or grant Haji Rafah's request to dissolve the State Legislative Assembly by virtue of Section 1, Clause 2, Clause B from the 8th Schedule of 8C. Now, we go to the second sub-issue, which is whether the Sultan's discretion in refusing dissolution was validly exercised under the Federal Constitution. So, based on the rule, 8th Schedule, Section 1, Clause 2, Clause B, as I said before, it is based on his discretion. And we can consider of the case of Datuk Seri IR Haji Muhammad Nizar bin Jamaluddin and Datuk Seri Dr. Zamri bin Abdul Qadir, where it stated that the Sultan's discretion is non-justiciable, i.e. it cannot be reviewed by the court and cannot be questioned by anyone. So, applicating the rule and the case law to the situation of Haji Rafah, the Sultan was acting on his discretion as based on Section 1, Clause 2, Clause B, and his discretion cannot be questioned or it cannot be reviewed. So, applying the case of Nizar and Zamri, the act of Sultan using his discretion to rejecting the request for dissolution is valid as his decision is non-justiciable and he is indeed acting validly on his discretion. Now, we go straight to the third sub-issue, which is whether the cessation of party membership of the 3 RP assemblymen resulted in the automatic vacation of their seats under the Federal Constitution. So, now we go straight to the 8th Schedule, Section 7A, Clause 1A of the FC, which is this provision stated that a member of the Legislative Assembly and his seat shall become vacant immediately on the date a casual vacancy is established by the Speaker under subsection 3 if Clause A, having been elected to the Legislative Assembly as a member of political party, I, he resigns as a member of political party, or second, he ceases to be a member of the political party. So, also in the same schedule, under Section 7A, Clause 2, Clause C, a member of the Legislative Assembly shall not cease to be a member of that Legislative Assembly pursuant to this section only by reason of Clause C, the expulsion of his membership of his political party. Applying the rules to this situation, the religious party president, Haji Rafa, he already stated that the membership of the 3 assemblymen was terminated or ceased on 24th December. Although the assemblymen may claim that this was a constructive expulsion which would not cost them their seats, that the speaker subsequently stated that there were vacancies would suggest that their act of signing the SDs on behalf of the party, which adverse to the party itself, was construed as the voluntary resignation of their membership by the party constitution, and so would result in the operation of the anti-hopping law, i.e. Section 7A, Clause 1, Clause A. Now, we go straight to the fourth sub-issue, which is whether the timing of the Speaker's declaration of casual vacancies affects the composition and majority of the Assembly. Based on the Section 7A, Clause 3 on the same schedule, it stated that, in summary, that this schedule wanted to emphasize that the Speaker shall establish that there is a casual vacancy and the Speaker need to notify that casual vacancy to the Election Commission. And also, in the same schedule, under Section 9, Clause 5, that the casual vacancy established under that within 2 years of the dead Legislative Assembly, which is according with subsection 3, stand dissolved. Such casual vacancy shall not be filled unless the Speaker notifies the Election Commission in writing that the numerical strength of the party, the constituent majority of all the members of the Legislative Assembly, is being affected by such vacancy, meaning that there can be a casual vacancy even though it already been 3 years of the dead on the death of the Legislative Assembly, on the circumstances that the casual vacancy affects the majority. And based on the case of Ronald Kendi and another, and Dato' Johari, if a member ceases seat in assembly, there will be a casual vacancy. However, the casual vacancy only can be established by the Speaker because the power is conferred to the Speaker and it is non-justiciable, which means if the Speaker has not announced a casual vacancy, the ceased members are still part of the Assembly. Applying the rules and the case law to the situation of sub-issue 4, the Speaker did not inform the Election Commission of the vacancies until 4 p.m. on 26 December 2025. But on the 6 a.m. of 26 December 2025 of the appointment of Mr. Elvis as the Chief Minister, the Speaker had not yet made use of his constitutive power to declare the seats to be vacant. So, applying the case of Ronald Kendi, the power to establish casual vacancy is on the Speaker. Therefore, it is fair to claim that at 6 a.m., the 3 individuals were still supposed to be members of the Legislative Assembly. So, if this view holds, meaning that Mr. Elvis had already fulfilled the support of 9 out of 15 members. But, after the Speaker gave notice at 4 p.m. on the same date, the seats were irrevocably vacant due to the notice of casual vacancy. So, the majority of Mr. Elvis at 6 a.m. is subsequently abrogated, which having them only 6 supporters which will not form a majority but a hung assembly. Therefore, a by-election needs to be held even though the assembly had taken place for 3 years since the first date of the meeting at the casual vacancies, as the casual vacancies will affect the separate of majority, which is stated in Act Schedule Section 9 Clause 5 of the Federal Constitution. So, the conclusion for sub-issue 3 and 4 that the 3 assembly still counted as part of the Legislative Assembly at the time Mr. Elvis was appointed as the new Chief Minister, even though their membership were ceased because the Speaker has not established the casual vacancy yet. However, their membership became truly ceased after the announcement by the Speaker, which affects the majority supports of Mr. Elvis, which this is an indicator for a by-election to be held under the Act Schedule Section 9 Clause 5 of the FC.
So, move on to the last issue is whether the appointment of Mr. Elvis as the Menteri Besar is constitutionally valid. So, to answer this, there is 3 sub-issues. First, whether Mr. Elvis in fact commanded the confidence of the majority of the SLA at the time of his appointment. Second, whether the Sultan validly exercised his constitutional discretion in appointing Mr. Elvis, and third, whether the Sultan's decision is justiciable by the courts. So, answering the first sub-issue concerns whether Mr. Elvis commanded the confidence of the majority at the time of his appointment. And this is important because under the Federal Constitution, the Menteri Besar must be someone who enjoys majority support in the Assembly. Under Schedule 8, Section 2, Clause 2A of the Federal Constitution, the Sultan is required to appoint a Menteri Besar from among the members of SLA who in his judgment is likely command the confidence of majority. In the case of Khairuddin bin Abu Hassan, the court held that the Prime Minister, and by analogy in this case Menteri Besar, is presumed to continue enjoying the confidence of the majority until the confidence is formally determined to be lost through a constitutionally recognised mechanism. So a mere withdrawal of support is insufficient. And furthermore, in the case of Muhammad Azizi, the court confirmed that an assembly seat becomes a vacant only when the speaker declares it and notifies the election commission. So applying these principles, at 6 a.m. on 26 December 2025, when Mr. Elvis was appointed, the 3 RP assemblymen who had withdrawn support from Haji Rafah still counted as members of the assembly. And although their party membership had ceased, the speaker had not yet declared their seats vacant. And at the swearing-in ceremony, Mr. Elvis had support of 5 UP assemblymen, 1 HP assemblyman, and the 3 RP assemblymen, giving him 9 out of 15 members. And since the majority is 8 members, Mr. Elvis clearly commanded the confidence of the majority at the time. And under Khairuddin case and Muhammad Azizi, no formal loss of confidence had occurred. Move on to the second sub-issue is whether the Sultan validly exercised his constitutional discretion in appointing Mr. Elvis as the Menteri Besar. Under Schedule 8 of Section 1, Clause 2A of the Federal Constitution, provides that the Sultan has discretion in appointing the Menteri Besar. And in the case of Datuk Dr. Zamri, the court held that the appointment of a Menteri Besar is within the absolute discretion of the Sultan, and the Sultan is not subject to the recommendation or approval of any other authority. The Sultan may appoint a member who, in his judgment, commands the support of the majority of the assembly. Move on to the application. At the time of the appointment, Mr. Elvis commanded the majority support. The Sultan exercised his judgment based on the existing composition of the assembly and appointed Mr. Elvis accordingly. Therefore, the Sultan acted within the powers granted in the Schedule 8, Section 1, Clause 2A and Section 2, Clause 2A, and the appointment was constitutionally valid. So move on to the third sub-issue, which is whether the Sultan's decision is justiciable and the effect of the Mr. Elvis losing majority support after his appointment. So the rule for justiciability and by election is that in Datuk Dr. Zamri, the court confirmed that the Sultan's discretion is in appointing a Menteri Besar is non-justiciable. And in case of Muhammad Azizi, the court held that the Speaker's declaration of a casual vacancy is valid and triggers constitutional consequences, including by-election. And also under Schedule 8 of Section 9, Clause 5, a by-election must be held when a casual vacancy affects the confidence of the majority. So applying to this case, at 4 p.m. on 26 December 2025, the Speaker notified the Election Commission that the 3 RP assemblyman seats were vacant. And this reduced Mr. Elvis' support from 9 to 6, meaning he no longer commanded majority confidence. And although this does not invalidate the original appointment, it creates a constitutional situation requiring a by-election to restore majority support in the assembly. So to conclude, Mr. Elvis' appointment as Menteri Besar was constitutionally valid at the time of his swearing-in because he commanded the confidence of the majority and the Sultan exercised his discretion lawfully. However, after the Speaker declared the casual vacancies, Mr. Elvis lost majority support and a by-election is required to restore confidence in the Assembly. So